after having extensive meetings with police and police and prosecutors. So we had no idea that Dr. Roth was going to come in as an expert. I had no way of doing background checks on his prior trials, his prior opinions, prior depositions, as well as those of Dr. Swanner. And I think that with all of the motions and arguments that the state has made about our experts, that we should have been entitled to those of anyone testifying in a murder trial against Dr. Husel, that were going to render opinions as it related to their opinion, their medical opinions, and their medically based opinions, which the two aforementioned statements and testimony clearly outlines. And for that reason, we would be moving for a motion for mistrial on those two issues.
Thank you, Your Honor. The court ruled on this, that not only were the questions appropriate, they were relevant and allowed to come into evidence. So I don't know if he's asking for a mistrial based on at Trinity stated that the people that reviewed this had no clinical experience. I believe he made that in reference to Dr. Taco Bradley, an assertion that is not true, but regardless, making the point that the administrators didn't know what they were doing, and the implication is that they were framing Dr. Husel without basis for murder, is part of their argument, and we can talk about why they're qualified to do what they're doing. We can talk about not only why they're qualified, but why they are doing it, because we're medical doctors with clinical experience, and this was alarming to us. So it's entirely appropriate to ask someone's background and why they're qualified to make a statement. We're not offering them as experts under Rule 16K, but as this court has ruled again and again and again, they are qualified to talk about what they do and what their experience is and why they did things in this case. Not rendering a outsider's opinion like the 5 experts that we gave them 2 years ago in their reports. That's a different thing altogether. These people are doctors with clinical experience, and that based upon that education, training, and experience, they are allowed to comment on what they did in this case and what their practices are. And the court has ruled, like I've lost count of how many times you've ruled, that's entirely appropriate in this case. So we have done absolutely nothing inappropriate. It is prejudicial to the defense. Everything we do is meant to be prejudicial to the defense. That's what we do. So I don't believe that is a valid objection in this matter. It's not, but just because something's prejudicial doesn't mean it's not allowed under the rules of evidence. What we do is meant to, we're trying to convict them. That's what we do. So there's no basis at all for a motion mistrial on what Mr. Bias just said. Thank you.
Mr. Bias?
No response. I think I just made my record.
Okay. The court has been discussing these types of issues from day one, the difference between subjective and objective opinions. I've also given living instructions to the jury on similar issues, and including that issue. I feel it's fair that they can comment about why they did a certain act. Okay, it does not allude directly to the doctor, it just alludes to what they're doing. I don't think it's been prejudicial at all, so the motion's overruled.
Thank you.
Okay, we ready? Okay, Ms. Schaefer, please.
It's my phone. I keep hearing it. I don't know where my phone is. I'm just going to take it all the way off just to make sure.
I'm sorry?
We're talking to each other.
Talking about what I'm going to do this weekend.
That's the problem with this bell I'm in. We have a judges meeting at noon tomorrow to discuss how long is this going to be up? Emergency meeting, I convinced them to pull it off.
It's just, I have soccer dad duties this weekend, so it's,
I'm glad all mine are grown, so.
How old are your kids?
Except I do have a grandchild coming in May.
I'm sorry, Judge?
I do have a grandchild coming in May, so I guess it restarts the
That
cycle.
restart, that's right, about 5 years. How old are you? Well, it's fun, it's fun.
by that time I'll have some comfortable lawn chairs for you, Your Honor.
You guys looking for something in the back here?
You got Dr. Rob?
Or? Okay, cool. Doc,
You want
come on
mine,
down. You can come on down. A 2-lawyer escort, wow. Two distinguished lawyer escort. Might as well have seen relax for a second. Are you okay, ma'am? Okay. You just look like you were bending over uncomfortably or something. Of course, I do have the reflection of the glass in the way, but the door is locked. Doo, doo, doo.
All right.
You can be seated. Good morning, ladies and gentlemen, Jerry. You have a good night? You all this up? We talked about some stuff before I let you go yesterday. I don't think there was any major problems or anything, so you can disregard all that now, I guess. The other thing I wanted to talk to you about, it appears because of Court Columbus, for the rest of the duration of the trial, we'll be stopping at either 4 or 4:30 on Thursdays. Okay? It seems like flights don't work any other way. Okay? I'll steal it from you, trust me, during lunch hour. Okay? But, you know, we want to try to make this work and people have their lives too as much as we can. So that'll be the rule going out. Okay? You can plan on recording. Okay? Okay, with that, we were currently with the doctor. Doctor, remember, you're under oath?
Sure.
Mr. Zion?
Thank you.
Good morning, Doctor. Counsel. Good morning, ladies and gentlemen. We left off talking about the pharmacy board. I believe we left off with you saying Mount Carmel Health, under your direction, voluntarily reported this incident to the pharmacy board.
That is correct.
If you are aware, did Mount Carmel Health settle with the pharmacy board?
Yes, Mount Carmel ultimately settled or came to arrangement on remediation with the Ohio State Board of Pharmacy.
Thank you. Yesterday, we talked about the size of Mount Carmel Health in Central Ohio. Are you aware what size it is in comparison to other, and we're talking about size-wise, other health systems in Central Ohio? 1, 2, 3, 4, 5. Do you know what its rank is?
I believe its rank is the second largest health system. I could be incorrect. But
And that would be approximately 9,000 employees, approximately 2,700 doctors.
2,300, I believe.
2,300, thank you. Did Mount Carmel, under your direction, voluntarily report this incident to the nursing board?
Yes, we did.
And why did you do that?
Objection.
I'll permit it.
Because we felt to the notion of being transparent, and that when questions would arise about the professional status or the professional responsibilities of the nurses, they were the right institution to investigate that aspect.
Was anything reported voluntarily by Mount Carmel to the medical board?
Yes, it was.
And what was reported and why was it reported?
Similar reason.
Okay,
Objection.
we're getting cumulative here off the other witnesses.
I'm sorry?
We're getting cumulative off the other witnesses. Why is that necessary? The question. You may. Minute and a half. It's all good.
Probably changed the note. I don't remember I changed. And the doctor was like, yeah, you need to go home now. He got his work done. I felt
We're still setting up there. I think you guys had lots of coffee this morning. The good coffee?
Yeah.
That's the most energetic I've heard you guys in the background. I don't even want to know what you were talking about. You got a problem? Your computer shut down. Uh-oh. Okay. Take a second. Back in the old days when everything was paper, you know, it had its problems too. Technology is a wonderful thing, but occasionally it bites us. So we're in the middle of one for my poor court report. Is it a battery issue? Huh? It didn't die on you, did it?
strengthen it, but he didn't have to do that. He literally wears it. He doesn't try them. What is it?
We're trying to get to know everybody's
No, we have Shanika. Other side. Right.
Okay. Mr. Zion? Ladies and gentlemen, we're going to get back going here. Mr. Zion.
I believe we left off with the medical. Did you self-report voluntarily?
Across the country, and they do so in some way on behalf of CMS, but they are our accrediting body.
CMS, what's that?
The Center for Medicare and Medicaid Services with the federal government.
Okay. And did you self-report voluntarily to the Joint Commission?
We did.
All right. And when did you do that, if you recall, approximately?
It would have been, I believe, in around January of 2019.
All right. Let's talk about Medicare and Medicaid. Did the hospital get in jeopardy of losing their Medicare or Medicaid funding because of your voluntary self-reporting?
So the voluntary self-reporting leads to a survey about the issues that we reported. On the basis of that survey, they found our hospitals here in Mount Carmel out of compliance with the conditions of participation, which then placed us in jeopardy of not being able to continue to participate with Medicare and Medicaid.
What particularly was out of compliance?
The particular area related to medications and medication safety.
All right. What, if anything, did you do to get back into compliance so that you would not lose your Medicare and Medicaid funding?
So we submit a plan of remediation that demonstrates that we will be able to be back in compliance very quickly with those conditions.
What happened next with that plan?
There was some back and forth with the Ohio Department of Health and CMS, or the Center for Medicare and Medicaid Services.
Objection, Judge. Hearsay.
Okay. Let's rephrase. He's okay so far. Doctor, you can continue. Overruled.
That plan of correction was accepted by the Center for Medicare and Medicaid Services, and that immediate jeopardy was removed.
Do you recall the timeline of when that plan was accepted and that immediate jeopardy was removed?
I believe it was early February of 2019.
Early February of 2019.
I believe that's correct.
Was that issue thereafter resolved with Medicare and Medicaid funding at that point?
It was not.
What else happened with that?
So because of that, in the usual course of process, the Ohio Department of Health, on behalf of CMS, comes back and does a more complete or comprehensive survey of all of the aspects of participation not specific to the issue that we reported.
Okay. What happened with that?
Similarly, they found issues with some other areas related to the conditions of participation. We had to submit a plan of correction for that, which was ultimately accepted.
And then were you out of jeopardy with that part of this was the state coming in, is that right?
The Ohio Department of Health works in conjunction with the Center for Medicare and Medicaid Services.
All right. And after that, was that issue resolved?
Yes.
And do you recall approximately when that would have been resolved?
Approximately March of 2019, to the best of my recollection.
Did any of those remediation plans that the federal government and or the state working in conjunction with the federal government regarding Medicare and Medicaid depend on your actions regarding Mr. Husel's criminal case?
Objection. Calls for speculation.
It's a direct question.
Still calls for speculation.
Okay. Rephrase.
Were one of the conditions of your remediation plan to fix the issues that were identified by Medicare, Medicaid, and state that Mr. Husel be criminally prosecuted?
No. Sorry.
Objection.
No, overruled.
Thank you. Number two, healthcare in the Central Ohio area. Trinity is a very large corporation, correct?
Correct.
We've heard from a previous witness that the hospital itself had an in-house media department.
They have an in-house communications department.
Communication, okay. What do in-house communication departments do in general based on your training and experience? And what, if anything, did they do in this case?
So in general, they do communications both external and internal about things that are happening within the health system. So both to our employees, our colleagues, to our physicians, but also to the external community, events that may be happening, new services that are offered. That's what they do in general. Specific to this case, they worked on how do we make sure that we communicate the issues that we're communicating with clarity.
Are you aware of whether or not, either at the beginning or prior to you becoming aware of the situation and coming down to Columbus to lead the hospital's response and investigation, are you aware if any outside media consultants were contracted to address the issues of Mr. Husel's dosing habits in the ICU during palliative extubations?
I am.
And were all of those strategies and all of those companies that were initially hired to deal with this issue, were they all implemented and used?
They were not.
All right. Referring specifically to States Exhibit 27A, previously identified yesterday as Defense Exhibit MCD-6. May I approach the witness, Your Honor?
You may.
Have you seen this document before, sir?
I have.
And where have you seen that document before?
I've seen it a few times. I saw it around the time in December of 2018 after that, and then it was produced to me through this process, I believe through your office.
For your review and preparation for your testimony today?
That's correct.
Does it appear to be a fair and accurate copy of the document you initially became aware of?
It does.
Is it fair to say that this document came from the playbook, as it's been called, or the strategies of Project Lighthouse?
It came from an early part of that process, yes.
All right. May I publish, Your Honor? I'll use the overhead.
Any objection?
Objection.
Okay. We're gonna take our luck today, huh? Hit the power button. Ms. Sawyer, he's looking for help.
Well, it's, okay, it's blinking.
There you go.
There we go. Thank you.
Okay.
Yes, good morning, guys. Yes, this morning, Jose Baez put together a motion for a mistrial because of state's failure to disclose expert testimony, expert reports, and the
Titled High-level questions for decision.
continuously repetitive nature of all these experts that keep offering.
What is
The judge denied it.
high-level question for decision that, is this, who made this document, if you know?
To the best of my knowledge, it was made by a communications consultant in conjunction with some members of the communication team at Mount Carmel.
Okay. And when you say, so this was an outside company contracted to respond to this situation?
Yes.
All right. And as we've talked about, what's their first question in this?
So the first question in the document is, who is the villain in our victim villain vindicator crisis communications narrative?
And does it give choices?
It does.
Does it give discussion topics?
It does.
Does it have a subsection C referring to Ed's decision?
It does.
Who is, if you know, who is Ed in this document? Who are they referring to?
Ed is Ed Lamb, who was the chief executive officer for Mount Carmel Health System.
All right. And then it's got a part two. We're talking about, do we want to talk about dying well, correct, and choices and discussion topics, correct?
Correct.
There is a page 2 to this document, continuing on with this strategy, correct?
Correct.
There is a page 3 to this document, talking about other issues and choices and decisions for Ed Lamb to make. Is that correct?
That's correct.
A page 4 to this document with discussions, choices, and decisions for Ed Lamb to make, correct?
That is correct.
And finally, a page 5 to this document with discussions, Ed decisions, and decisions for Ed Lamb to make, correct?
Correct.
All right. Does this document in any way have Mount Carmel or Trinity Healthcare letterhead on it in any of these 5 pages?
Not that I can identify.
All right. And just so everyone's clear, not that this wasn't in Mount Carmel records, but this is not in any way indicated that it is a Mount Carmel document.
Not the document that you're showing, no.
You see this, what, if anything, do you do regarding this plan and or this media consultant that came up with the plan?
So as we learned more through the investigation process, the conclusion was that that was not the right direction for our communications approach as the facts of this situation became public. And so we chose to go with to change communication consultant and use a different one and have a different approach.
All right. When you say you changed the communication consultant, you didn't use this company, you went with a different communication consultant.
Correct.
Hired another outside firm to actually deal with your response.
That's correct.
All right. Was that plan ever implemented?
It was not.
So what was, as far as the media consultant and the plan going forward after that plan was discarded, they were fired, or not used, I don't know if fired is the word. What was, in your mind, the plan going forward in communications to the public and to the reporting agencies and to everyone?
So the plan was to be transparent with the public about the things that we had learned, the actions that we had taken, and the reporting that we had done up until that point. and on an ongoing basis. That we had to acknowledge that there are things that we needed to change, and that we were taking quick and decisive action.
And did that include the reporting agencies you talked about? Going to them voluntarily?
Did our communications plan include that?
The plan going forward with communicating to people, to the public, everything.
Yes.
Did that include communicating, once it was okay with the prosecutor's office, to the families directly?
Yes.
And did that include speaking to the public about this through media?
Yes, and our colleagues.
Meaning the other 2,700 doctors and 9,000 employees.
2,300, but yes, that's right.
2,300, I will get that right, my apologies. 300, I don't know why I have 27. All right. Do you know how many documents were in the Lighthouse project, approximately?
Can you clarify what you mean by documents?
Well, how many pages if you were to print them out in order?
Through the entire investigation?
Yeah,
Thousands, if not tens of thousands.
all right. You've told the ladies and gentlemen of the jury about your education, your experience as a clinician. What, if anything, did you do in regards to identifying potential victims in this case? Dr. Husel, regarding his dosing habits during palliative extubations in the nighttime of the ICU.
Objection.
Sustained compound, move, re-ask.
Did you do anything regarding identifying the patients that could have been victims in this case of Dr. Husel?
We didn't.
What did you do?
We ran a series of reports to try to identify patients who would have been impacted or were potentially impacted by these doses or similar doses.
Can you explain to the ladies and gentlemen of the jury how these reports were run, what parameters there were, and what their findings were?
So these reports look at a time frame.
Judge.
He's right, sustained. Let's rephrase it.
Are you aware of the parameters of these reports?
I am.
Can you tell us what the parameters were?
He can tell us his understanding of what the parameters were? Is that what you're asking?
Yes, sir.
Okay.
So my understanding of the parameters of the reports in total were to look at a variety of things, including the medications used, the doses used, patients' outcomes, where the doses were used, those types of factors were in those reports.
Why would it be significant to know where those doses were used? From your understanding?
Yeah, from my understanding, sometimes doses like these are used.
Objection.
Okay. Let's go ahead and rephrase the question to him. He's getting a little beyond you.
Are these doses used 500, for instance?
Objection. We
Okay, so let's do sidebar. Okay, guys, come on. You were so energetic last time. We have to bring more coffee?
I did. I need to wake up my brain.
Still working? Good morning. Hold on. Mr. Zion.
Thank you. I believe we left off with before the lack of, so everyone's clear, Project Lighthouse reports that were run by Leslie Moore. You were discussing parameters. What is your understanding of the parameters?
In general or for each of the reports?
In general, and then for each report, if you can define, if you have an understanding of what that is, not a pun, but just your understanding.
In general, those reports were meant to broaden gradually the scope to make sure that we were identifying any patients who had received doses that were potentially excessive. I do not recall the specifics of each of those reports.
Do you know in general what those parameters were?
In general, those parameters looked at the varying thresholds or doses of the different medications, the locations where the medications were administered, the time frame between the medication and patients dying. Those are generally the parameters.
When you say location, why is location
Jim,
It's your understanding, you just did this.
I understand.
I withdrew that.
Why is location important? What do you mean by location? And if you understand, from your understanding, why would that be important?
So the location in question was the intensive care unit or on our medical surgical units. It was not the operating area or procedural areas.
So that was excluded from these run reports.
Yes,
And what is your understanding of why that was excluded from these run reports?
because
Sorry, on what reports?
Run reports, lighthouse reports, whatever you want to call them.
because while patients are under anesthesia and on a ventilator, doses may be needed in this type of range commonly.
Okay. So that is excluded for that reason, is your understanding.
To my knowledge and understanding, yes.
All right. Do you know how many of these run reports were made?
Cumulatively, I do not recall, not collectively.
Do you know why different run reports were made? Were any of the variables changed regarding doses, time in between administration, dose of death, et cetera? Were any of those changed in any of these run reports?
And you're talking about the first 5 reports.
Five.
Yep.
So there was 5 run reports from Leslie Bolton.
From Leslie Bowman,
Okay,
that's
you
correct.
have one question on right now. You just added another question while he was in the middle of the answer. So
Okay.
let's go back and do it in an order that's organized, please.
How many reports did Leslie Bolton run?
To the best of my recollection, there were 5.
And why were there 5, to the best of your understanding?
Because those reports gradually broadened the criteria to make sure that no patients were missed.
Did you see all of these reports initially?
I did not.
Which one, did you see some of these reports initially?
Initially, like as they were run, no, that was prior, some of those reports were prior to my direct involvement.
All right. At some point, did you see these reports?
Eventually, I saw these reports.
All right. Did any of these reports, when you initially saw them, contain a person we've designated as TY? Do you know who I'm talking about when I say TY?
I do.
All right. Tell us about whether you were aware of patient TY initially,
I was not,
and why not?
because I learned about patient TI before I went into that particular report. That was a report that was done prior to my direct involvement.
All right. What, if anything, did you do with those reports run by Leslie Bowman yourself?
We used those reports to review the medical records of the patients who were identify patients where we felt the doses were excessive and we needed to communicate that with family members.
And how many patients were identified in these reports?
Ultimately, 35.
And so 35 families were contacted eventually, ultimately?
Ultimately.
At some point during your involvement in this investigation, were any employees of Mount Carmel placed on leave? Besides, we've heard about Mr. Husel's leave. Besides Mr. Husel,
Yes, other employees were placed on leave.
do you know how many pharmacists were placed on leave?
I do not know the exact number at this point.
Do you know if any nurses were placed on leave?
Yes, they were.
Do you know if any other doctors or administrators who were also doctors were placed on leave?
Yes, they were.
And do you know approximately when they would have been placed on leave?
To the best of my recollection, the majority were in January of 2019, but as new cases were discovered, sometimes other colleagues, nurses, pharmacists were placed on leave as those cases came to our attention.
At some point in 2019, was a decision made on these nurses, doctors, and pharmacists, besides Mr. Husel, regarding their continued employment at Mount Carmel?
Yes,
Do you know if any pharmacists were terminated from employment at Mount Carmel because of their involvement in Dr. Husel's dosing habits in palliative withdrawals?
yes, some were.
Do you recall the number of them?
I do not.
Do you know if any nurses were terminated as a result of their involvement in the dosing habits of Dr. Husel during palliative withdrawals?
Objection.
I'll permit it.
Non-argumentative questions.
I understand the objection overruled.
Yes,
Do you know the number?
I do not recall the number.
Do you know if any doctors and/or administrators that were doctors, were ultimately terminated because of their supervisory role of Dr. Husel while he was administering these doses during palliative extubation?
Yes,
Did you know the number of that?
I do not remember off the top of my head, no.
So we have the run sheets from Leslie Bowman. What, if anything, do you do with those run sheets? What, if anything, do you do with those run sheets?
Are you referring to Project Lighthouse, or are you referring?
Project Lighthouse, the run sheets, so we're being specific, the run sheets, Project Lighthouse, that were compiled by Leslie Bowman, the things we talked about yesterday and today.
We review the medical records of those patients that are identified, and in some cases, I interview the clinicians and caregivers who were involved.
All right? And is this part of a criminal investigation, or is this part of the hospital's investigation?
This is the hospital's investigation.
Based on your investigation, based on your looking at these run sheets, digging into these run sheets, Leslie Bowman, did you create any document or any compilation based upon that?
Me personally?
You personally or your team at your direction that you would be familiar with?
Yes.
All right. I'm going to show you what I marked for identification purposes as States Exhibit 27. Do you recognize States Exhibit 27, sir?
I do.
And for the record, it is a two-page document.
It is.
Does it appear to be a fair and accurate copy of that document?
It does.
Can you explain what States Exhibit 27 is?
Yes. That was a document that, so at that point in time, we had publicly said that we identified 27 patients. This would have been on around January of 2019, that we identified 27 patients. The Franklin County Prosecutor's Office asked me to produce that report, which spoke to the facts of dosing and patients and timing and other factors, but the facts from the medical records on those 27 patients.
All right. So that we're clear, this was prepared for your internal hospital review, but requested after the fact by the county prosecutor.
No, that was prepared at the request of the Franklin County Prosecutor's Office specifically.
All right. So this was the compilation you prepared for Ron O'Brien.
Correct.
All right. May I publish, Your Honor?
Objection, Judge.
We're going to have to go sidebar here. I can imagine what needs to be discussed. Ladies and gentlemen, I'm trying to figure out what that pounding noise is. That's why I sent the bailiff off. So you're gonna have to help me out a little bit and talk amongst each other while we work. Okay? I don't know about you all, but that thudding above my head was not making me happy.
What's going on there? No idea.
we find out who the culprit was? There's a what? A field trip? Is it one of Judge Brown's? Okay, then it's okay. I'm kidding. Okay? Sometimes they don't realize that we're working down here, so. You may, next question.
Thank you. So you are calling the prosecutor, telling him what to do. The prosecutor called you and told you what to do.
Objection, is this cross-examination?
I'll permit the question.
Can you restate the question, please?
He wants to know, you did your work according to the direction of the prosecutor in producing that item.
That is correct.
All right. And that document was based on the hospital's internal investigation.
That was based on the medical records.
All right. And you also indicated that you or your team actually interviewed clinicians that were involved in those cases?
As part of the hospital investigation, yes. Yes.
That's right.
Yes.
Did they publicly announce 27?
Yes, to the best of my recollection, that's correct.
And then at the direction of Mr. O'Brien, you put it in a report and brought it to him.
Yes,
And did you personally bring it to him?
I did.
And did you sit down with Mr. O'Brien and the...
Was that I did?
He
Yes.
said, I did, yes. Remember, you're in the fishbowl there, okay?
And did you then thereafter sit down and discuss these cases with the detectives and Mr. O'Brien prior to this case being charged?
That report I discussed with Mr. O'Brien and Mr. Lowe. I did not discuss that report, to my recollection, with the detectives.
Do you recall if other people were there?
I believe in that meeting, it would have been just Mr. O'Brien and Mr. Lowe, though another member of the prosecutor's office may have been there.
At some point, did you discuss that with the police?
Discuss that
That
report?
report or those findings?
No, not to my recollection.
Do you recall when that meeting would have been, approximately?
That meeting would have been, to my best of my knowledge, around January of 2020, or 2019, I'm sorry.
2019. Doctor, based on your understanding of the hospital's investigation, were there any other physicians, and there's approximately 2,300 in this system, correct?
Correct.
Got that right, Doctor? Of the 2,300 other doctors in this system, outside of the OR, patients off the ventilator, were there any other doctors in the entire system giving doses of 500 micrograms or above of fentanyl?
Objection.
I'll permit it.
Outside of OR procedural areas or not on the ventilator, no, there's only one physician.
And who was that one physician?
That was Dr. Husel.
Thank you. I have no further questions.
Cross, Mr. Baez?
Do you want any of this stuff up here?
Yeah, you can do that.
All of it? Well, these are my notes, so I'll take those. I left this. This is one of these things.
You guys holding up okay?
Yep.
Okay. Didn't know if you wore your guys out with the conversation, so.
One moment, Your Honor.
Judge, I think we may need to address something sidebar before I.
Okay? Well, we'll take our break here. Let's take a couple minutes so you guys can go do whatever your jurors do. Okay?
All right.
Let's come back at 10:30 and we'll continue on.
No, I'm good. I got it.
You want to go sidebar over here,
Yes.
guys? Have a great break, guys.
Thank you. Just real quick.
things you did in reaction to what you saw. Okay? My question to you goes, did you ever review any of the trial preparation peer reviews and get rendering an opinion today?
Ever reviewed trial preparation peer, can you?
Peer reviews, reviews by doctors about any of the facts in this case.
Did I ever once read something that was that was created under peer review? Is that your question?
No, my question is, there were a series of.
Sounds like I missed all the stupidity.
And there were reports generated relative to some of the. As to some of the performances by the doctor on various types of cases.
I'm just want to answer your question clearly. So you mean external groups that reviewed some of these records?
Yes.
Did I read their reports?
Yes.
Yes.
Okay. Okay. Mr. Tom, who represents the hospital here today?
I do, Your Honor. Louis Gao on behalf of Mount Carmel.
Scott, I have a problem now. What's the hospital's position?
So I don't believe Dr. Austin, we can ask him, I don't believe he reviewed those reports in anticipation of testifying today. But during the course of his regular job duties in responding to this incident, he did review those reports.
Which makes no sense because they knew there would be a prosecution.
I think you can clarify that, and we maintain privilege over those materials. And Your Honor has ruled, as I know you may have said it sidebar, you ruled approximately a year ago after the in-camera review in which we provided those. We did agree during the privilege litigation earlier in this matter to a stipulation with the parties. And per that stipulation, we agreed to produce the really external peer review for 1 through 35 patients. Those have been produced to both sides. And then we also produced some additional.
That's not surprising, Shannon. He's been there the whole time, I guarantee it.
On the condition that neither party would seek any of the additional material on our privilege. And so that would include the additional Greeley reports, as well as other material that was contained on our privilege.
Okay, well, here's the one I had. We're testifying here, and there's been these mystery reports all of a sudden. And he's rendering testimony based upon them. I think I have a problem all of a sudden because of the situation. You can maintain your privileges. I'm going to take 2 minutes, think about it. I understand your position, but I want to think about it. Okay?
Okay.
Is there any questions on this issue of the witness?
Can I have a moment, Judge?
Can I just ask you a question? Are we off the record?
Yes, Toby, it's me. Hello.
Get off the record.
What the specific document was on the phone.
Yeah, hi, Toby. My name's Sean Martin. I'm an attorney out of Cleveland, Ohio, and I was covering this one just because it's local, but cover all kinds of criminal stuff.
Questions for the witness.
Thanks, guys.
Shannon, I came in right when this happened, so I don't know. I was on a really long phone call.
Okay, we're back on the record. Mr. Bias.
Dr. Roth, you would agree that the Greeley reports are peer review reports that have to deal specifically with just Dr. William Husel, correct?
Correct.
Your Honor, now we're getting into the content of the Greeley reports, which we've maintained the privilege on. If we need to do this in camera, I think we could probably do that. But again, once we get into the substance of what's been withheld as privilege, we risk potential waiver issues.
I understand that. I would sustain your objection. His question was reliance. That was the whole purpose of the inquiry. Is there anything else?
Yes, the report that you testified to today about that involved 2,300 employees, that was separate and distinct from the Greeley report, correct?
Can I clarify your question? May I clarify your question?
Yes.
It's glad you can't
Yes.
answer it because it's not clear.
Correct.
Okay.
Okay.
Rephrase.
The report that you referenced in your testimony, was it discussed with the prosecution prior to your testimony today?
Greeley report. Is that Lighthouse?
No, Your Honor, if I may clarify,
Okay.
the Greeley reports were included on our privilege log. Greeley is an external peer review consultant who will look at medical files and make a determination
Okay.
on a peer review basis. It was all done at the direction of Mount Carmel or Trinity attorneys.
I looked at that a year ago. I didn't remember the official name. Should I?
Yes. The report that you're discussing is not part of that report, correct?
The report that said
That,
only one provider, one physician had ordered.
correct.
So can you restate your question, please?
Yes.
Wants to know if that one person thing we've been talking about all morning, was the Greeley any part of that?
It was part of that.
Hold on. Anything else?
This report, was it? I'm trying to ask the question without getting into privileged information.
Well, we'll stop you if you do.
Could I help and clarify the record?
Sure, maybe you
Potentially?
can, yeah.
I just want to make sure it's clear. The report, though, that was not introduced into evidence, but that was discussed during your testimony, that was not a report that appeared on the privilege log. It's separate and distinct from Greeley, correct?
Correct.
And was that what you're getting at?
Yes.
And is it true that the report that you, again, was not admitted into that evidence, but that was discussed during your testimony, that was a report generated in response to a subpoena that was issued by the defense asking for any doctor system-wide who had administered or ordered 500 micrograms or greater? Is that correct?
That is also correct.
And just for the record, Your Honor, and this is a proper from counsel, once that subpoena was issued for 500 micrograms or greater system-wide, we realized that could include people in the operating room or ventilators, and it would probably be over-inclusive for the purposes of this trial. So we negotiated with the defense to limit the subpoena only to doctors who had ordered it outside the operating room or off a ventilator. And as part of that process, Dr. Roth, utilizing some of the data runs, utilizing some of the material that does appear on the privilege log, conducted that review, and we created the chart that, again, was not admitted into evidence, but that was discussed during direct testimony.
The Greeley information he used
So this
was
chart
the
includes
things that were
privilege
surrendered
information.
in the agreement.
So
Guys beyond that.
I would probably ask Dr. Roth to clarify what was used rather than me
Okay,
testifying.
well, doctor, what did you use out of a Greeley? That's the proper name for it.
Well, and there are more than one.
This is not good.
So I'm also wanting to clarify.
Not very good here at all.
Which is still under privilege. Is that a fair question to clarify?
Yeah.
Okay. So we did review that as part of the review of the medical records for some of the patients that were identified in the data run.
Okay, there was an excess of 500 reports,
500.
500 individual peer reviews.
Patients, I believe patients, Your Honor. I think the
No.
issue was, I'm sorry, I think the issue was with the request, you have a number of physicians and a number of hospitals. So you have to whittle that down to see which medical records you would look through, see which patients were indeed on or not on a ventilator. And so as that process, you need to use some data so you're not looking at every single patient who's been treated at every single hospital and having to go into the medical records. So that was the process of winnowing it down to patients who could have received these doses outside of our operating room or on a ventilator. But then it actually required going into the medical records and determining if they were on a ventilator.
This is the state's witness. I'll explain more in a minute.
Generated via a data run. There's not a parameter that can be set.
It basically comes down, he's been talking about his understanding of why things were working. Okay, and we kept talking about the Lighthouse report. Evidently, he reviewed part of the Greeley report.
Reports and evidence that have not been
Trying to
admitted.
Figure out the extent. If it was the 35 you surrendered and that was the only part he did, then privilege law stays. If he went beyond that, then we're gonna have to make a quick plan because I'm basically gonna lose the afternoon. And we'll have to figure out logistically what we're doing. So, do you understand what we're talking about, Doctor?
I believe so, yes.
Critter, this is huge right now.
You go beyond the 35 reports?
For the purpose of generating the report in response to the defense, we used a broader report that had 400 patients. That we didn't use all 400, but some of the patients we used from that report.
Some of the patients use.
So that means yes.
So some of the patients that were in the report.
No, it's privilege for the hospital. Their own legal
I'm a regular
privilege.
jury, and I'm a fault. Yeah, go ahead.
Just for the record, so that I have it in my mind and that it's clear on the record. This was all at the request of the defense that this was done. But by agreement and stipulation, you did this and said, we will look at this privileged material at your request and give you a compilation of our results without waiving privilege. Is that what happened here? At the request of the defense?
I don't think this witness can answer what.
Okay, well, I've got his lawyer here. Do you want to tackle that?
I'm happy to. So we received the subpoena and we narrowed the scope of the subpoena so that we could be responsive to it. And then we undertook our exercise to get the response.
Stop. He's under oath. He's a lawyer and officer of the court, so he knows the ramifications of all the nice things I can do to him if he tell me a whopper.
Of course. So we narrowed the scope, and then based on that, we went about our work to be able to provide a responsive report. It was not a report that was already in our records. We had to use the existing material we had to generate that report. We had to undertake efforts to look in the medical records to determine if the patients were or were not on a ventilator. And that process allowed us to create the report that we produced to the defense, and then we also produced it to the prosecution.
Is that this report?
That is not this report.
There it is.
It's a separate report.
Is this report based on that set?
No, this report was generated well before the report that we've been discussing. That was the 500 micrograms of grade only Dr. Husel report, just for sure.
You have your-
You have everything we
You
did.
do.
And our report was about Dr. Husel.
Okay, time out, folks. I'll let you guys talk about that elsewhere here. Any other questions of the doctor?
No, nothing saying.
Not from the defense.
Okay, you can step up.
Yes, sir.
Don't take them away, but take them out. Okay?
Is this better on the mic volume? One of you guys said I was really loud.
It was up there.
No, it's not up there.
I said it was.
Anything else for me, Your Honor?
Don't go very far. Stay right there for now. We're on the record.
We're still going, guys. I want to hear this.
I'm gonna
I'll
bring
explain in a
the
minute.
jury in I'm gonna fall on the sword and say I have to do my judge thing. And I'm gonna give them an early thing. Everybody has until noon tomorrow to give me their position in writing. Okay, if you want it under seal, we can arrange that, since I imagine you're gonna want to yell under seal. Okay? And then I'll make a decision. I will try to have that done by 2:00. It's a Simo thing, you won't be able to respond back to the other side, so make your best shot. Okay? If we disseminate it, we have it all electronic, and we can do that. Okay?
A game of high card.
Just for clarification, and I'd ask the defense to respond, so I have it in my mind. Big picture here, what they're saying is, they're objecting to the testimony that identifies Dr. Husel, who is the only physician in the Mount Carmel system, outside of the OR, off a ventilator, administering a dose of 500 mics and above. That is the issue here, correct? Is that the issue? Because I just want to make sure we're writing about the same stuff.
No.
And then not having the data that backs that up.
No.
Okay?
Judge, I think we need to know, I think the court needs to review exactly what it determined was privileged before we can take to the next step. We have no idea what this court determined to be privileged and whether in fact, I'm sorry?
That's why it's privileged.
Right, so what we were asking is that the court review, whether in fact, it reviewed and made the determination to be privileged, and to see if this report is included in what was reviewed by the court and determined to be privileged. Because if it's privileged, prosecutors shouldn't be asking questions about it.
Okay.
Especially since, and that's what I think we were asking the court to do.
Yeah, this is how I see it, okay? Before anybody else talks. I was required to make a decision, I'll turn on my mic. I was required to make a decision about a privilege law, okay? There is this thing in there, but it's also directive of the underlying reports, okay? So the peer reviews. So it had the appearance of trial prep and work product within that aspect of it. All of them are at a completely different standard of this case. So there is that damage possibility there that someone tried to use it when it's on a completely different standard, and that's a battle we'll have to fight in the future if I release them. I haven't heard anything yet that makes me want to release it. I do have concerns about the extent he did it there. I may just release the report, not the peer reviews. That's why I'm giving you guys until noon tomorrow to tell me what I should and shouldn't do.
Your Honor, if I may, to the extent, and I'm not sure if this was what Mr. Byers was requesting, but this report that was introduced to Dr. Roth, I put together the privilege log, which all the parties have the privilege log, as well as the in-camera package that was over 2,500 documents, pages that the court reviewed. This was not in that privilege material. So I just want to make that representation of the parties. So this report and the report that wasn't introduced that Dr. Roth testified about was not within the privilege material.
Okay.
That's just, hold on. Can we pull up the report that has the title on it?
Can I ask one question on the record just to make sure?
Yes.
Your Honor, may I have the floor permit just to confirm?
Yeah.
Okay, so from my understanding, what we're writing about, this is for you, Louis, is defense requested how many doctors hospital-wide were doing this, and that is when this issue, you guys would run this report and review confidential material that we stipulated everything wouldn't be waived. So this was all done at defense's request to determine how many doctors hospital-wide were doing this.
Okay, that's not quite the way.
I was just trying to
Defense issued a subpoena, they filed a privilege log in response to it. which means I have to do an in-camera review. Okay, I went through and I basically gave up 5 days of my life going through this. Okay, I mean, I was doing it about 12 to 16 hours a day to get through all the documents. And you guys are well aware how many documents already exist. Okay, I made a decision as to what was privileged and what wasn't. And there wasn't a lot that went out because of the nature of what it was. Okay? My concern here today is the doctor said he relied upon this magic report partway. Okay? I'm trying to understand two things. One, this report was generated far after the incidences where he created the lighthouse. Okay? At least my belief is that. It may not be completely accurate, okay? The second issue becomes, even if he relied upon this report, to what extent do I have to review? Okay? Because there's some narratives that go on analyzing what's out there, and then there's the peer reviews. So I may give the analysis, but not the peer reviews. I'm not quite sure yet. Because quite frankly, the peer reviews, they're done on a completely different standard for a completely different purpose. And I really don't see where my gut is. I don't see where they're at issue here.
So what is the exact objection that we are addressing in our written responses?
Well, what it is it's a request for additional information. That's how it all started. Whether because of the testimony of the last doctor indicated he relied upon things, that brought up the issue of mystery reports. I directed everybody to go out and talk to counsel for the hospital and see if we had those, if there was anything else, and that brought us to this. I think that fairly represents what's happened.
Kind of.
Okay, I love when people tell me kind of.
Here's the thing I think the board needs to consider as well. Dr. Swanner yesterday testified to some report that was obviously not the 5 reports that are utilized to impeach him because it was brought up during redirect, that this was some other report. Dr. Swanner was fired from, or put on leave in January. He was not involved and even fired in July. Any requests from the defense to generate this report he would not have had access to that. So how in the world is Dr. Swanner getting to access to the reports that may or may not be privileged, as at some point we're all going to determine. But he's certainly testifying to this report that was either allegedly or possibly made as a result of a defense request. So for that reason, I think what we have to do is we're going to have to go through all of what was turned over, the voluminous number of documents that we're looking at, to see where that lies in comparison to with what the testimony has been to date.
Okay, let's stop for a second. You had your right to interlocutory appeal. Okay, I made the decision based upon what I had. Okay, it is a standing order right now. Okay, if you all want to try to convince me why I should come off of it, fine. But what the doctor said yesterday, he relied on something, that doesn't help me in this situation. Okay, it's my understanding that all these documents were prepared after he was gone.
Right, which is why we need to figure out how he's testifying to a report.
But you don't know that's the report he's testifying to. No one got out of him anything along the lines of what we talked about today. Yes?
I was just going to say that, Judge, that he said he was aware of it. They had the record available to see exactly what he said. He was aware of that. And then they did have an opportunity to cross him on how he was aware of that, pointing out that the Bowman run lighthouse reports or particular to Husel. So they had their opportunity to test his knowledge of that statement. They did cross him on that. That's like you said, I was just agreeing, I was just going to reiterate what the court said. You made a ruling on that. This is about Dr. Roth, I believe, for tomorrow, limited to Dr. Roth.
Well, Dr. Roth is Monday now. We're not working tomorrow, guys. No one was planning on it, were you?
I think we just got confused because you said our responses were due tomorrow.
Your responses are due tomorrow. You're working,
Yeah.
but we're not working. Well, we're working, but
Judge, can I request a little bit longer than noon tomorrow? I think given the number of documents that this involves.
okay.
It's quite a bit.
For the argument, why would you need longer? Because you don't know what the documents are. They're privileged. We're dealing with the concepts.
Okay, then
Okay, I have to be back on Monday. Okay. I thought tomorrow was fair. I can go 5 today if you wish. I mean, if you're gonna say, if we get past, I might go 2 o'clock, but past that, it's unfair to me. Okay?
totally understand, Judge. If I could just inquire or ask the court to inquire, the court reporter, how quickly we can get a transcript. I think we need to get transcripts of the testimony from both of the witnesses that is relevant to this alleged report. So.
Do you need a minute to figure that out?
I can't write and talk at the same time, so. This actually is a rough draft of this transcript.
Assuming all parties agree a rough draft is fine? Yes, and you can text or call or whatever about the spelling, and errors are okay. Spelling.
Ooh, wow, they're getting a transcript ordered up.
And we are looking at all the testimony of Dr. Swanner and Dr. Block.
No, I think we could give search terms that could help with not having to do full transcripts.
She is going to be hating
Just
her
picture
life
that
right now.
concept. What as soon as I hear completeness?
Yeah, I'm worried about that.
And I'm not trying to make her a buck. I'm just saying, hey, you know, aren't you just better off just to order the entire thing? Because it was in and out several times in the testimony. Oh, she's got her paper.
No, I was trying to see.
No, I wasn't talking about you.
I was just making a cost,
That's fine.
you know.
I'm just trying to, you do it the way you want.
No.
You're the one using it.
I think we resolved.
Okay, I don't know what you're trying.
Your Honor, would it be possible to have a sidebar to talk about Swanner's testimony yesterday regarding his report? I think I maybe
Sure.
for some clarity. Thank you.
Well, yeah, Shannon, this is the inner workings of a train wreck, like flaming carnage train wreck. So what happened? The witness started talking about. Actually, we got to go back in time, and we need to actually mute these guys, and I don't know how to do that. Hold on. Oh, there we go. I can do that. Okay. So the defense has the right to documents. They have the right to file subpoenas to get documents and get a hold of those things. Can everybody hear me? Okay. So the way it works is the defense files a subpoena, which is an order from the court demanding the hospital turn over documents. So the hospital does, but it says these are all privileged information. Privileged for any number of reasons: HIPAA, patient confidentiality, internal review, work product with another attorney, XYZ, whatever privilege reason. Well, to get through the privilege, generally a court will review those documents if it comes to it. And given this is a hospital, the judge decided to review the documents. And as you heard him say, he spent one whole week of pulling 12 to 16-hour days reviewing documents. And the way he phrased it, it sounds like he kept most of those privileged. And he agreed that there was privileged material in there, and he was not able to divulge those to the defense. Now, it sounds like that didn't kill the defense because they got what they needed. But now you have this witness coming in, and he's talking about privileged materials. So now he's testifying to things that nobody's had access to, testifying to reports there's no evidence to, testifying to possibly hearsay that nobody knows about because those witnesses haven't been called. So now that's an issue of confrontation. Is that fair? There's also the additional issue of this guy having been canned by Mount Carmel way before this report was ever made. This report was made way, way after everything had gone on. So that's like reading a police report that was written years after the event. It's not a good look. And also, just real quick side diversion. If you guys haven't noticed, Mount Carmel fired a shitload of people because of this. I started doing some research on it. They cleaned house. A lot of people got canned. So if you're noticing, that's a very common theme here with a lot of people. They got canned if they were in a position of command. So the judge is bringing up, and this is where Mount Carmel's attorney comes in saying, and he's been there the whole time, his job is to protect the hospital. And he does that by handling the witnesses. And he tells the witnesses what they're allowed to talk about, what they're not allowed to talk about. Now, normally, you can't, I can't shape somebody's testimony. That's not allowed. What I can do, I'll get to that, Toby. What a attorney can do, and you may see this when you see people from like the FBI or whoever testify in front of Congress, they can tell you, you cannot talk about X, Y, or Z, and you'll have to invoke privilege. And it sounds like this guy didn't do a very good job at following the rules he was given, so he started talking about crap that appears to be privileged. And that's a problem potentially because there's ways you lose privilege. The one way you can lose privilege, such as attorney-client privilege. If one of you were to come into my office and sit down and speak to me as a lawyer about a issue you had, civil or criminal, there's attorney-client confidentiality. It's privilege, what we talked about. I have no authority to disclose that to anyone. There's ways you can get around that. The first way is you can waive that privilege. You can actually sign a written waiver saying, I allow Sean Martin to talk to whoever about this case and what we talked about. That's a way I'm authorized to do it. There's a second way privilege can be done is if you disclose it. So if you go and talk to your attorney, you come and talk to me in my office about a murder that you committed, everything you tell me is private, but if you go down to the bar and tell everybody you've now disclosed that to third parties, so they are allowed to know. And the police could go talk to them, or the prosecutor could talk to them. There's no privilege between you and just random people. So in this case, the judge is also concerned that privilege may have been breached. And all those documents he had, well, now they're breached. Now, okay, well, if they're breached, that means they're discoverable. Now the defense gets a chance to have them. So there's a bunch of different things they're going to be arguing. You can see all the attorneys are over there. This is going to be a train wreck. In addition to all the attorneys, the court reporter's over there. Because this guy's testimony is critical. What exactly did he say and how did he say it? So she's going to have to go back and get a transcript knocked out for this guy. For a court reporter, when they type on that little computer, it is a shorthand computer. So if you were to look at what they have, unless you've been trained in shorthand, it looks like gibberish. So they have to look at it and translate it, and then they have to format it in a way you can read it and present it to the court. So she's going to be working her ass off to get that done. I don't envy her there. But yes, this is a big mess because if that's the case and privilege has been breached, by the state's witness, there's discovery out there. There's confrontation issues. Now, how did this happen? Um, do I think the attorney screwed up? I mean, possible the prosecutor screwed up and the Mount Carmel attorney screwed up. But really, this guy, I've listened to him a little bit at the beginning. I heard him testify at the beginning a little bit. This guy sounds like a dope. I mean, he sounds like an idiot. That's what it really sounds like to me. This guy's just stupid and he screwed up. And he started talking about this junk, and now there's a problem. Now, yes, you heard the idea of an interlocutory appeal, and that's where you tell the judge, we're going on timeout. We want to appeal this ruling. That's generally rare, and if that were to happen, God, this trial's going to get postponed for like another 2 months. So, Shannon, we're not worried about. Don't mention appeals right now. Well, Miss, why don't they use a speech to text program? Because it's not as effective. I mean, this is the way that's guaranteed to work. And it's the way we've relied upon now for decades because we know it works. There's a system in place. Text to speech is getting better and better and better. And what happens nowadays, if courts don't have the money for a court reporter, they just have recording software. That software records, and then you give the recording to a court reporter who you hire, which there are companies that just have court reporters that do depositions, transcriptions, they'll transcribe videos, whatever, and they'll sit there and type it out. And yeah, things are getting better, but we're still not to that level. And thing is, courts are very conservative. Technology is rough to get into courts. We're finally now getting full steam on that. Like this 10 years ago would not have happened. You would not have lawyers with laptops open. That was frowned upon. When I first started practicing in 2014, that was kind of frowned upon to have an iPad or a laptop, unless your judge was fairly forward thinking about technology. Exactly, Toby. They're inherently conservative about that. Yeah, well, miss, but we have a system that we know works and everybody's accepted and agreed that it works. Then let's say, the issue with using those transcription programs, let's say use company A versus company B. We're going to have to, I think at that point, yes, those laptops should be closed or blacked out. Thankfully, we can't read them. But yeah, I would not. That's the state stuff as much. I don't really care what happens to them. But, going back to your thing, miss, let's say you use company A and I want company B instead. Well, if we're using this to reliably show, like I make an argument this isn't reliable transcription. Well, now I want to see your source code. How do we know it works? Oh, nice to meet you too, Toby. So you see the problem there. Well, that company's not going to give up its proprietary information. You don't have to give up proprietary information when you have some lady going like this at the table. You ask her what's going on. But that's what it sounds like it's going to be. It's going to be a massive argument arguing about, it sounds like some confrontation issues and the privilege. The defense is trying to say, yeah, thanks for stopping by, Toby. Look forward to it. Like and subscribe. Anybody here that's new, yeah, please like, subscribe if you like what you see and you like what I have to say. Even if you don't like what I have to hear or say, still subscribe anyway. I appreciate that. Get me closer to getting that Raid Shadow Legends money. But yeah, this is going to be a big undertaking. This is, this isn't blowing the case wide open, but this is a separate issue within the case. Oh yeah, the trial stopped. They're going to stop to work this out. They can't have him continue testifying. They're done till tomorrow because for that court reporter to do a transcript, she stopped working right now. She can't keep working. It will take her hours to get that done. And then for these attorneys asking, they have basically 24 hours to knock out a motion. I could see these motions being at least 10, 15 pages. Hopefully I get to see them. They get uploaded. If they get uploaded, we can probably take a look because tomorrow I have some court hearings. And sadly, they're in the afternoon. But I can be on in the morning and we could talk about them. So that may be an option we can do. That's the good news. But yeah, that's where we are. This is a pretty big problem. Uh, I doubt there's, and the other issue is it sounds like it was fairly prejudicial towards Dr. Husel. But once again, like I said, I have concerns. My theory is this is a convenient scapegoating in that I will be live tonight, but if they aren't done yet, they're not going to be done by tonight. They're going to work on this all night. So we won't have a chance to review it. We might talk about it a little bit tonight, but I don't think there's any smoking guns here that blow either side out of the water. Oh, they were not scheduled for court tomorrow. Okay, well, hopefully that helps them because then I can take a look at this stuff. And I might do a if that's the case when I'm done with the court tomorrow afternoon, I may actually do a live stream in the afternoon and we'll go over the documents, see what they're talking about. If you guys are interested. Yeah, I heard the number of documents they gave to the defense was tremendous. Yeah. I mean, think about how big your medical file and records would be if you went to the hospital for a week. It's massive. Okay. Now couple that with somebody who's dying, has probably been there for a bit, and then dies within the hospital. That these are going to be massive records. I guarantee it's terabytes of data so far. I mean, think about the judge having to review documents, and he's reading them as fast as he can, and probably if they're in PDF format, he's like page up, page down, page down, page down, page down, next page, next page, next page, trying to get through what's interested. Hi, Bob Murphy. Hi, Christy Taylor. Sounds like some new faces. Anyway, yeah, this is a massive, potentially big problem because that's all discovery that neither party's had access to. Remember, the judge said he had a whole week of looking through this crap, and he only let out a very small amount of it. So think about how much junk that really is. All these documents, all this paperwork. Yeah, MedMal firm. Yeah, Also, Star, that's neat. You're in Cleveland too. Yeah, I'm over on the east side. But yeah, guys, please like, share, subscribe if you're new. I'd appreciate it. Normally there's a picture of me. For some reason, my laptop in my office does not do camera. But think about all those documents that might be in there and words and things they might talk about and who they talk to, which means now that's not only you read the document, but now, hey, there's a new name. I want to go talk to that guy. Oh, I got to talk to you. Oh, you might have something I need. Oh, hey, here's a subpoena. You're coming in to testify. Oh, you're West Coast now. Okay, well, yeah, you're not close anymore. That's probably about 15 minutes from Shaker Heights, though. So what does this all turn into then? Well, it's just another layer of things that have to be looked at. So yeah, this is potentially a problem. We shall see, though. If the court determines privilege hasn't been breached, then that's it. Now, I will say the judge mentioned doing like a limiting instruction to the jury or disregarding evidence. Well, maybe, but I also told you jury's already heard it, so that information's in their head. They can't unforget it. Well, Miss, I'd say Jose Baez is fairly sophisticated. When you're doing higher end things like this, you learn, and it's not hard to learn enough to know how to navigate. It also helps that your client, in this case, is a highly skilled, highly trained, and fairly smart doctor. Dr. Husel, I think we talked about yesterday. Sounds like he did some of his residency work at the Cleveland Clinic, one of the best hospitals in the world. I mean, people come from all over the world to get work done there. He is board certified in 2 separate parts of medicine, which is ridiculous. So it helps when your client is very intelligent and knows his thing inside and out because you can rely on that. But also, I guarantee you Jose Baez probably has some medical experience, probably doing some civil work. And as an attorney, you can rely on your previous experience, but you can learn up on stuff, and as a defense attorney, you can get like the crash courses in different things. Like I've gotten crash courses in different types of jobs, and how you do different things, enough that I can question witnesses, and that's enough. Yeah, Rennie, you can kill the feed. It's Dunsky. I think we're done today. We aren't coming back. Jose Baez is incredible to find a crack in the prosecution. Well, okay, Laurie, I'm not going to go that far. I'd like to think I know I could do some of this too. Maybe not to the same level, but I'd like to think it's fairly obvious what was going on. I'll put the banner together I worked on. So that's kind of where we are with things. Yeah, that's really it right now. This is just it's very interesting. Do you guys have any other questions real quick we can talk about? I can. But it sounds like that's it for today till we find out what they filed. Sorry to cut it short, guys. I will tell you, I went through all of Brett Hankins's testimony last night. I have a big thing put together. We'll talk about that tonight. And I don't know if you listened to it, but Hankinson did not do himself any favors. He basically admits he shot at bright flashes through a set of blinds. Yeah, at that point, it's, he didn't really have anything he was doing. Oh, why was this all during, Little Miss? It was done during pretrial. Pre-trial, defense asked the hospital for all these records. Oh, yeah, he cried. Well, and I understand. Probably getting shot at is scary. But, it's also scary when you air condition someone's apartment that didn't do anything. Why was this done during pretrial? It was done pre-trial. The defense asked for the documents. The hospital said no. So then everybody asked the judge to sort it out. The judge did sort it out. And now this witness came in and fucked it all up. So everything was set. Everybody had made agreements. Everybody was all set. We all knew the rules. And then this witness comes in and screws it all up. So that's the problem. It was all done. Well, no, I don't blame him for crying. You're sitting there trying to do your job, and your buddy's laying there on the ground almost bleeding to death, and he's screaming, and there's blood everywhere, and it's loud. Somebody just shot at you. Bullets are screeching in the metal. Your friends are scrambling. You're scrambling. You don't want to get shot. Like, that's not like telling somebody, like, they're fake crying. Like, you ask somebody who's been there and done that, whether it's in the military or in a police situation. Like, when the bullets start screaming into stuff and people are bleeding and dying, it changes how people think about stuff. I mean, it will get to you. It also sounds like this was the first time he'd ever been shot at, but it can be insanity. All right, well, if he's on the bench, I will put stuff up. Hold on, guys. Hold on here.
A lot to do today. Okay? You're not drawing inferences from it either. So I'm going to give you the rest of the day off. Okay? Unless you guys want, of course, you guys might want to sit back here all afternoon and have a good time. Okay?
Yeah, sit there back there and drink free coffee.
It changes your pay. Okay? Not that some we give you. Please understand, if I could do it any other way, I would, but I don't have a choice. Okay? So I've got to get some stuff done. Okay? Not like I've been ignoring things, but there are always things that come up in trials. Okay? You're not taking any inference from it. Okay? Let's get started.
Aye.
Remember, I'm giving you Fridays off. I figured you could use the rest. Okay? Have a wonderful weekend. Remember the admonitions. Don't discuss the case. Don't do any of your own investigation and ignore the media.
Don't do dumb shit like this, attorney.
They were live while some of it was going on. I don't want you to have any
I'll talk
idea
about that in a
what's
second,
going
Shannon.
on. Okay? We understand each other? You want to see an upset judge? I'm a pretty nice guy. You want to see an upset judge? I'm the wrong guy to get upset. Okay? So let's follow the rules. We'll get started Monday at 9. Okay? Bailiff, call them up.
All right.
You guys have a great weekend. At least I hope you all do. And I apologize for doing this to you guys, but I have no choice.
So yes, I will be on tonight at 9:30, and I'm probably going to do something tomorrow once we see what they file. And I only say that because they're not going to get it filed today. If this takes a long time, what happens to the jury? Well, then it takes a long time. I mean, OJ's went for how many months on end? It was like 8 months long. So, the juries do what the juries do. But yes, ultimately, guys, this is an issue of privilege, and I'll probably talk about privilege a little bit more when we're in, our stream, so we can probably discuss it more, and you guys can belt out some questions. But yeah, 9:30 tonight, 9:30 Eastern time. We'll do a stream tonight about this, kind of what happened tonight, and also I'll rewatch this guy's testimony to catch up on what happened. But I'll probably also talk about Brett Hankinson, Robert Hayes, the guy down in Daytona Beach. He was going through his death penalty phase. It's something we can touch on real quickly. And touch on some of the other stuff we had from last week. Also, I get to say for Curtis Reeves, neener. I got it right. But yeah, we will be on tonight, and I will do tomorrow. Lori Beth, he's, no one was charged with Brianna's death, yes, but his is the closest connection to it. He did not. So Robert Hayes did not get the death penalty? Wow. I mean, I knew about his case. That was not nice stuff. But, Lori, tomorrow I'll be covering what they filed in this case. So the briefs that the judge wanted from them, from Jose and the prosecutor, that's not going to be done. Like, they have till noon tomorrow. They're probably going to take as much time as they can get. So it won't be till tomorrow. So I will take a look at all that, and we'll talk about it tomorrow, because it won't be done. All right, guys. Yeah, since nothing else is going to happen, I'm going to go ahead and dive into some work and get it going. So, guys, see you tomorrow, or actually see you tonight. Tonight. And also tomorrow.